going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you're having a great day so far. Happy Thursday. It's Thursday, right? Thursday? Yeah, it's Thursday. And Happy New Year. I'm double checking it's Thursday. Yep, it's January 1st, Thursday. Happy New Year, everybody. Thank you so much for hanging out with me today. I know there's not very many people here. Probably won't be today. I just, I've got a long video to play, and I didn't want to do it tonight. I feel like, a lot of people are going to be out doing, out and about doing stuff today, or just kind of lazing about. So if you're one of us and lazing about today, then we're going to enjoy this long one. It's about 2.5 hours long. It is it's not even a landlord tenant case. It's a landlord's in trouble. Yeah, we're gonna find out all about it. And this did happen about 2 or 3 weeks ago. I don't remember 100% what happened. So we're gonna be watching it at the same time, kind of new together. I remember the basics of this case and what happened. And I remember it kind of goes downhill fast, and you'll see. Landlord's in trouble. Anyways, you guys ready? I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back lips. Let's go.
All right, we are on the record. This is the matter of Julia Lee Pankow versus the Planning and Development Services Department of the City of Boulder. I do want to start with Ms. Pankow. Are you ready to proceed?
Yes.
Ms. Keller, are you ready to proceed?
Yes, Your Honor.
All right. So a couple of things for.
Your Honor, I apologize. You are muted on Zoom.
That's interesting because the record is on. Huh. I mean, I'm typically muted on Zoom. I don't ordinarily turn on my microphone because it'll get that feedback. Can you hear me? That's very true. Yeah, there's feedback.
I'm just reiterating what our clerk said over Teams, so I'm not entirely sure where the issue is.
Sabrina, are you able to hear me now?
All right. Nothing like starting the stream off with some technical issues, right? Right?
Sabrina? Let's see if we can get Greg back in
Hey,
here.
Neil Morrison.
To look at the sound issue.
Thank you so much for the 22 months. I appreciate it. That's awesome. 22 months. Neil Morrison, thank you. Yeah, true. It would not be Zoom. Usually we don't see this from the judge having technical issues, though. It's usually a defendant. Judges use this all day.
That she can hear.
Oh, okay. All right.
False alarm.
Apologies for that. Not sure what the issue was, but I do want to go over a couple of things with you in particular, Ms. Pankow. And am I pronouncing it correctly?
Yeah.
Right. So first I want to talk about the process of what's happening. So you received back in, is the sound still not working?
No, I was just told.
Oh, okay.
Looks like it's working.
Yeah, I think it's working now. Sorry, thank you.
It's okay.
And I'm just pulling your case up, Ms. Pankow. So according to and all I'm saying is according to, not saying it's properly issued. I'm not making any of those judgments at this point. But how we got here, let's talk about that for just a moment. is you were issued, looks like back on November the 12th or thereabouts, a notice of agency action purportedly for having violated Chapter 915.1 of the Boulder Revised Code regarding an illegal dwelling unit or units. It's also alleged to be your second offense, and the penalty that was assessed to you as part of that notice of violation, notice of agency action, was $300. You then filed a notice, appeal of agency action, on the same date, so it was a timely appeal, and specifically, you raised some defenses to the notice of agency action that was issued to you, both with respect to the underlying allegation as well as the civil penalty. So that is how we are here. And just so
Hey, what's up, Doc Ock? Hopefully you're doing well. Happy New Year to you.
you know what my role is, I want to go over that with you. So this type of hearing is what's known as a quasi-judicial hearing, meaning it's partly judicial, quasi-judicial-ish, if you will. It is a review of the agency's action.
Is that how that word's pronounced? I always thought it was quasi. Is it quasi? Huh. Maybe that's just I don't know. Is that a kind of, it's pronounced differently depending on where you are? I don't know. I always thought it was quasi, though. That doesn't really matter. It's the same word.
So I am here only to look at the agency's action. And that's under section 6125 of the Boulder Revised Code. And it allows
What does that mean exactly?
I'm just telling you what you're talking about what is quasi-judicial?
No, what does it mean, agency's action versus other things that?
The agency's action being issuing you the notice saying you violated and assessing you a $300 penalty.
I see. Does that mean we cannot look at like the underlying structure, the reasons that happened, or we will?
Well, that would be potentially a defense. I don't know anything about the case. I don't look at it ahead of time other than the notice itself and your appeal so that I know what the issues are potentially going to be. It would have to be relevant. But what we are here to look at is have you violated the code? And it's the city's burden to prove that.
Hey, I appreciate it. Is this the Grim? Like Grim? I don't know if they call me Grim. I don't know if that's a different Grim or still, I don't know if it's you or not, but I do appreciate it. Thank you. Hey, Hedwig. Hedwig Flies Again is here. Man, I need to do earlier streams. We got a lot of people that I haven't seen in a little bit coming back. I love it.
By preponderance of the evidence. And then a discussion of, certainly if I find you have not violated, then there is no penalty. If I find that you have violated, then, you can make some argument about why the penalty should be less. But that's specifically what we are here to look at. Is there a violation? So in terms of, any defenses you have to it, it would have to be relevant to that. And we'll deal with that stuff as it comes. All right. So, like I said, you do have a right to a hearing. You recognize that. You filed a timely notice for a hearing. And as I just mentioned to you, it's the city's burden to prove that you violated not beyond a reasonable, but by a preponderance of the evidence. And if the city does that, I uphold the order, the agency violation. And if the city is unable to prove that by preponderance of the evidence, then
Well, good to see you, Graham. Good to see you, bud. I feel like this case is taking forever to start. It hasn't started yet. She's just going over the rules, I guess. I don't know. But once it starts, it is a good one. But it is long. I'm going to tell you that right now. It's a long one. Maybe this is why. She goes over the rules a lot. I don't know.
I would set aside the order and there would be no penalty.
Can I ask you a question?
Certainly.
I saw that the city sent a number of documents in to kind of back where they're coming from.
And I'm going to ask you, you're very soft-spoken.
Oh,
So if you'll tilt that towards you, I'm kind of soft-spoken myself, but I want to make sure we are making a record of this today and I want to make sure it picks up your voice.
Okay.
So if you could start over with your question.
I just saw in the email that the city had submitted a number of documents to support their case. And I was wondering if I can also include documents that I have on my end. I didn't know how to do that.
And in the quasi judicial rules, it talks about you're supposed to do that ahead of time. Generally speaking, we try not to make things so hard on people that, it's impossible to come here and what's the word I'm looking for? Effectively appeal the issue. Now, what I would say about that is we'll address those one by one, and the city will have the opportunity to object to it. But generally speaking, if I find the city is not prejudiced by the late disclosure of the exhibits or whatever it is that you have, then I would allow it. If I believe the city would be prejudiced by it, I would not allow it. And I'll give you an example. If you, had something from an expert witness that, it's probably not even possible for this type of proceeding, but if you had something from an expert witness and that you wanted to present, and that wasn't presented ahead of time so that they could have brought their own expert witness, then that's going to be prejudicial to the city.
Understood.
Does that make sense?
Yeah, I mean, I generally have things that the city also had access to, like conversations with them.
Well, it's not so much that the city had access to it. It would just be,
Yeah, that's what I kind of thought it meant. Somewhat or close to. I think hold on, what was the as if or almost? Yeah, I was thinking close to. Like when you say like it's we always used to use it as we were talking about athletes, oh, he's kind of a quasi Tom Brady, which means, he's close to a Tom Brady, but not quite there. Like that's how I've always heard the term used. Not always, but that's how I learned the word. So yeah. Anyways, quasi, what did she say? Quasi? At least we know what she's trying to say. Words are hard.
I would make a determination for each thing you want to present.
Okay.
And it would be based on that particular exhibit, whether or not it's prejudicial to the city being able to have been on notice and present their case today.
Okay. And should I send them to you now so you're also able to look at them, or should I just?
I don't look at anything, and that's why I haven't looked at theirs either.
Okay.
It's why I don't look at anything ahead of time, because I don't want to be prejudiced myself. I have to, and that's part of what I was just about to tell you. So I make my decision based on what is presented and makes it into evidence today. If you were to present something that didn't make it into evidence, then I wouldn't consider that. So it would need to be presented here in this courtroom this afternoon, and it would need to be accepted into evidence for me to consider it. And I don't want to taint my brain, so to speak, with any knowledge of the case outside of what's going to be presented right here today.
And in terms of presenting, does it qualify as presenting to just read it or speak it? Or do I need to somehow provide have everything?
Oh, that is a great question. Doc Ock, first off, thank you for the 18 months. I do appreciate it. Year and a half. Thank you. That is a good question, though. I think they would run with that. I don't think they would ever stop running. They would keep going.
In PDF.
And so you don't have it on paper. So why don't you do this? Why don't you take your exhibits and send them to, how many do you have?
I just have one PDF. I compiled them.
Okay, I want you to send that to B desk, as in B as in boy, desk as in the thing you're sitting at.
1 second.
We do have a clerk monitoring this proceeding remotely to assist us with documents. So you have one PDF, but how many different documents are in that PDF?
Let's see. I've sent it to BDesk. There are 24, I believe.
24 different documents?
Yeah, it's been a long and ongoing unfolding situation.
Okay. And so our clerk that's monitoring remotely, if you can take a look at that PDF that's being sent to you, and as best you can, break it into 24 separate documents.
They're numbered.
Okay, and they should be lettered, but somebody will be able, and it said that in the judicial, quasi-judicial rules as well, how exhibits should be labeled. But yeah, it's.
Oh, I think she heard us. She said quasi that time. Didn't she? I think she did. I don't know. I don't know what's going on yet. I'm just waiting for the actual trial to start. I should have just cut all this out. We're 16 minutes into this, and we haven't even started yet.
It's lettered for you. That said, I see a note from the clerk that she is going to label them and start getting those uploaded.
Thank you.
And they are numbered 1 through 24.
Mm-hmm.
So just change those to A through X, I suppose it is.
Yeah.
I have counted my letters correctly. All right. So let's talk a little bit about the process of how this is going to work today. The city has the burden of proof. They have to prove to me that you violated the ordinance. And because of that, they get to go first and present whatever evidence they have, whatever witnesses they have, that sort of thing. Then, so for instance, Ms. Keller, who is the prosecutor sitting at the table and will be handling this case for the city attorney's office, she would put on her first witness, ask that witness questions. You have the opportunity to ask the witness questions when she's done. So she will do what's called direct examination of that witness, since it's her witness. Then you would have the opportunity to do what's called cross-examine that witness. Then you would limit your questions to pretty much the subjects that Ms. Keller covered. And it can also go, if you've got stuff related to credibility, that can come in as well. But then once you're done, Ms. Keller, based on the things that you asked, would then be allowed to redirect the witness to do follow-up. So that's how that would work. And whatever witnesses she has, this would happen with every single witness that she has. She does direct, you get to cross-examine. She does redirect if she has any, that sort of thing. And then potentially I might allow a recross as well. All right, then when the prosecution is done with their witnesses, they do what's called rest their case. So they're done with their case. At that point, you will have the opportunity to bring your witnesses. And do you have any witnesses today besides yourself?
I mean, I was more relying on the documents that I put together.
Okay, but you would be able to testify that what those documents are and that sort of thing?
Yeah.
Okay, so you didn't bring anybody with you to testify, it's just you.
Yeah, just
okay, just making sure. So then you would get up and you would present what you want to present, limited to what's relevant to the issues that I have to decide today. Ms. Keller would then have the opportunity to cross-examine you.
okay.
And then based on her questions, you would have the opportunity to follow up. So it's just follow up based on her questions. Then when you're done with your witnesses, which is just yourself and your documents, then you would rest your case. So then there would be, after that, there would be argument about, it would come, again, start with Ms. Keller, since she has the burden of proof. She would argue why the city has proven its case against you. You would then have the opportunity to argue why that is not the case. And then if she cares to, Ms. Keller would then have the opportunity to follow up on your argument. And the reason she gets to go twice is because she has the burden of proof.
Okay.
So in other words, long story short, she's got the burden of proof. If she puts on her case and she hasn't proven her case, you never even have to say anything. The burden is on her to prove it.
Okay.
So you don't even have to put on any case at all if she hasn't proven it. Does that make sense to you? And that's why she gets to go twice.
Will there be a space where I could request a specific outcome or no?
That's the argument.
The argument. Okay.
And then, I mean, in theory, you can make a motion when she's done with her case, and you could say, I don't think she's proven her case, and you would need to tell me why you don't think she's proven her case. You can't just say, I don't think she's proven her case.
Okay.
So you can do that if that's what you were asking.
Yeah, I think so. And when it is my turn to speak and kind of try to prove my case, is there an order, a specific order in which I should present information?
I'm not sure I understand the question.
I don't know how to better phrase it.
You mean like chronological order? Or-
Yeah, chronologically or kind of, or the things that are strongest or most applicable to my case.
I mean, I think it's going to depend. Because I don't know anything about the case, it's hard for me to answer that question.
Okay.
You know, certainly you want to present your strongest arguments, absolutely. And anything else that you have might be so tangentially related that it's not relevant. I don't know, but I think we'll have to cross that bridge when we get there. And it will be whatever makes sense to you. All right, so how we start, I sort of have talked to you about the process, but how we start is, again, Ms. Keller gets to go first, but an opening.
I might just fast forward the next couple minutes and hopefully it's starting. I'm I'm so over this. Let's go, guys. It's my video. I should have absolutely went through and cut this part out, guys. I do apologize. This didn't have to be a 2.5-hour video. I found that out now. But she has explained the process. So yay, we understand the process now.
Statement, if she wants to make one. And then you get the opportunity for an opening statement if you want to make one. And what an opening statement is, it's a summary basically of what evidence you believe is going to be presented.
Okay.
It is not argument. It is simply, here's what I think the evidence is going to show.
Right.
Then she starts with her witnesses. Cross-examination, recross. She rests her case. You can make a motion if you care to. Then it's you and your witnesses and evidence. Then you rest your case. Then it's time for closing statements, which is argument.
Okay.
Here's the evidence that's been put on, and this is why I should win because of that evidence.
Okay.
Okay?
So that's last.
That is last.
Is it okay to ask questions at various?
I was just going to tell you that is perfectly okay. We understand that you are here pro se. You're here by yourself without an attorney, and it is perfectly okay for you to ask questions. Now, that said, I cannot give you any legal advice. So I might tell you, you're asking me for legal advice. I can't answer that question for you. But certainly procedurally speaking, or if
You just gave her 20 minutes of legal advice. That's what you've been doing. You're telling her the entire process. I guess that's not legal advice. It was her telling her how it works, but she's helping her.
you don't understand something, absolutely, I don't understand what that means. I try to do a good job of explaining, we'll have a conversation about something and I'll say, okay, this is what we were talking about in non-lawyer language. So
Okay.
that
Does
is,
that apply to things that Mia says if I don't understand something?
yeah,
Can I ask?
absolutely.
Okay.
Yeah. Like I said, I try to do a pretty good job of getting ahead of that and saying, okay, what we were talking about is this. And in plain language, that is what this means. But if you don't understand something, stop me and we'll halt proceedings so that you can get an understanding of that. And last but not least, the only other thing I would say is, if you have any objections to any evidence that comes in, you may hear Ms. Keller make objections. You need to state a legal reason why something shouldn't come in. So it's not, I object because I don't like it. It's, I object, and just tell me in plain language, and I will try to rephrase it for you. But it cannot be just, I don't like what this person is saying, I object.
Okay.
Okay? And then one person talking at a time, because this is being recorded, and we want to make a clean record.
If I do object, do I just say that whenever, or do I wait till she's done with?
No, you can say object. Sorry, I guess for objections, you may object at the moment. But
Heather, hi, Heather, hi.
Don't keep talking at that point. Let the proceedings stop. Then I'll ask you for your legal basis.
Okay.
Okay. Any other questions for me?
No.
All right then.
Your Honor, I have a quick question.
Yes.
If the court staff is prepared a copy of her intended exhibits, could I get a copy as well? I'm a little concerned that nothing has been provided to me before today's hearing pursuant to the quasi-judicial rules. And I'd like an opportunity to review these.
That is a fair request. And I don't know if the court clerk, I see copy, but I don't know.
Okay, yeah.
Does that work?
I can give you, actually, you have my email.
Okay. Now, the one would be A, 2 would be B. Are you concerned about that, or you want the actual copies?
No, I just want to be able to review what
Okay.
she intends to present, so I have a fair
That is
opportunity to
absolutely fair and reasonable. So let me know as soon as you get that, and then we'll get started.
Thank you. I think it's gonna have to do the attachment scan.
Oh, might be a minute is what you're saying?
Yeah.
Okay.
Trying to find you. There it is.
All right, so you've sent it at this point?
I just had to locate her email address.
Okay, let me know when you've sent it.
I found it.
Okay.
It's just taking a second.
Okay. Do you want to wait for that to come in, or and have the opportunity to look at it before we start, or?
Not
Just-
necessarily, Your Honor.
We're absolutely not watching the same video then, because this has not been interesting yet. And I don't know. Let's see. And I like doing this. So we are 20 minutes into the stream. The video, so we're 28 minutes in. I am 24 minutes. So I've been talking for 4 minutes, and that counted the 2-minute intro. So 2 minutes I've been talking. So that you're right. I never shut up. 2 minutes out of a 24 minutes I've been talking. Yeah, I never shut up. All right. I think we're almost ready to start.
Maybe a brief recess before, once the city rests.
Okay.
I just would like a few minutes to look over them, so I'm not caught off guard.
Absolutely. That is more than fair.
I work for the city of Boulder and
Oh,
Honor. The city would like to call Code Compliance Specialist Chad Napick.
I just started fast forwarding. She must have only taken 30 seconds to look over this. I went back.
I don't know. Maybe I'm a bit confused on how, so maybe I should waive it.
You'd like to wait?
Suppose so.
Okay. All right, Ms. Keller.
Just received Ms. Panko's exhibits.
Excellent. You may call your first witness when you're ready.
Thank you, Honor. The city would like to call Code Compliance Specialist Chad Napick.
Mr. Napick, you'd step forward, please. I'm going to have you come up here because you're going to be testifying. And then before you sit down, I'll have you raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated. Go ahead, Ms. Keller.
Mr. Mavic, could you please state your name and spell your last name for the record?
Chad Napick. Excuse me. Knapek.
What is your occupation?
I work for the city of Boulder in planning and development as a code compliance specialist.
And what are your job duties in that role?
I enforce the Boulder revised code and handle complaints about the code.
And can you talk about your experience in code enforcement?
I've worked for the city of Boulder in parking enforcement for about 4 years and then transitioned over to planning and development in my current role.
I believe it's involving whether or not she can rent her units or not, where she was told not to until she resolved a bunch of issues and then she continued to rent. I think it's something close to that. So is it major? I don't know. It's probably somewhere in between minor and major.
For the last year and a half, close to a year and a half.
Mr. Napick, how did you first become aware of a potential code issue at 1945 Colba Drive?
I was notified by Kimberly Barnett, who works in rental licensing, short-term rental licensing, June 23rd it was.
And what did she notify you of?
An illegal ADU.
Did she give you any other information?
She sent me, which is typical. She sent me.
Phil, I think Duval was just saying I don't cover anything serious. I think at least that's how I took it.
A copy of the Airbnb ad. So I clicked on it and was able to see. So I was able to move forward from that.
And just for clarity of the record, is 1945 Kohler Drive in the city of Boulder, state of Colorado?
Yes, it is.
Did you investigate who owns 1945 Kohler Drive?
Yes, I did.
And who owns that property?
Julia Benko.
What was the code issue you ultimately investigated at 1945 Kohler Drive?
It would be 915.
What is 915.1?
That's general provisions for illegal dwelling units.
Can you define an illegal dwelling unit?
Yes, it's in this case, it would be something against the code. So in this case, we were looking at the illegal ADU, which would be the kitchen that doesn't conform to the short-term rental.
Was the kitchen the only issue with this property?
We didn't know at first until we investigated and found that it no longer had the internal connection to the main dwelling.
And is the internal connection to the main dwelling required under the Boulder Revised Code?
It isn't unless it's permitted, which it was at one point.
Is this unit permitted now?
No, it isn't.
What would need to be done to this property to bring it into compliance with the city of Boulder Code?
At this point, the internal connection would have to be reestablished to the main dwelling.
Have you visited 1945 Kohler Drive to observe the code issue?
Yes, I did.
Approximately how many times?
It's been 3 times.
When did you first go to 1945 Kohler Drive?
June 30th.
And that's of this year, 2025?
Yes, it is.
And what what did you observe when you arrived?
I went with my coworker, Carl Eckinger, and we observed cooking appliances and are no longer in a internal connection.
And did you take photographs when you visited?
Yes, we did.
Mr. Nabek, just a second, I'm going to share my screen with you and I'm going to show you what has been marked as the city's exhibit one. Do you recognize exhibit one?
Yes, that's what we observed on our first meeting.
And this is the interior of 1945 Kohler Drive?
That's correct.
How do you know?
All right. What do we see wrong with this kitchen? There's not a stove. Looks like there's like a plug-in electric. I'm going to guess that's like a griddle of some sort. I don't know if I've ever seen a kitchen without a stove. Is that what the issue is? There's no dishwasher, but that's not terribly odd. Yeah, I don't know. Let's see what the issues are.
Because the address in the mailbox and I'm like,
Sorry, let me rephrase that. How do you know this specific photograph is the one taken in 1945 Kohler Drive?
we took this photograph.
Right. And is it a fair and correct copy of the photograph you took at 1945 Kohler Drive?
Yes, it has induction. So
Oh my gosh! Stop saying the address. the I don't know if this is a prosecutor. It's a some sort of prosecutor. She said the address like I don't know 12 times. Okay, we got it.
top and the stove.
I do have an objection.
No.
Your Honor, I haven't moved for admission at this point. I'm not sure
So-
what she's objecting to.
She's just asking, this has not been admitted into evidence. She has not asked for it to be admitted into evidence. So once assuming she says it, once she says, move for admission, then you object. Okay? You're on the right track, most definitely. You are on the right track. All right, go ahead, Ms. Keller.
For admission.
Okay.
Okay. I just don't believe that a visit happened on June 30th. I was out of the state.
So that is something you cross-examine on. So the objection would be to this particular exhibit. You're objecting to testimony he gave, and that's not a proper objection. That's something you can explore when you cross-examine him. Exactly. No, I don't expect you to know this. So let me ask you this. She's moved for admission of this exhibit 1. Do you have a legal objection to this photo coming into evidence?
I suppose so. I don't believe that there was a visit at that time.
That's a separate issue. I'm talking about just this photo.
Yes.
So you do have a legal objection to it being admitted, or you do not?
I do have an objection.
Is it based on the date?
Yeah, it's based on that I don't believe a visit happened on it.
Okay, I'm asking just particularly about this photo. Is there something about this photo that you legally object to in terms of it coming into evidence? In terms of the date, you can cross-examine.
If it was taken on my property without me present and someone entered the space when I wasn't there, then yes.
Do you,
Yeah, I'm sorry, Sharky. I mentioned this, I don't know, 3 or 4 days ago that I was planning on doing this today. I don't think I said it since. I've talked to Heather about it, but I don't think I've actually announced that I was going to do this. So I do apologize. I should have given more of a heads up. I did throw it on a Discord about an hour before the stream started, but yeah, I was slow to move this morning. But Sharky, good to see you. And Cincinnati Reds, let's go. I thought exhibits were to be AB. Yeah, I don't know at this point. But she's objecting to the same thing. Do you have anything else to object to besides when this picture was taken? Yeah, when the picture was taken. No. You can cross-examine on that. Do you have anything else? Yeah, when the picture was taken. Do you have anything besides when the picture was taken? Yeah, when the picture was taken. Okay, we get it. Come on.
That's a different issue. So in terms of this photo, do you believe it does not fairly and accurately represent the interior of your unit?
It's a timing issue because I have not been given time to correct the kitchen from when Kimberly advised me to make changes.
Okay.
So I would say I do object. I don't feel it represents my compliance.
Understanding that, is there anything about this particular photo that you legally object to? You're talking about, I didn't have enough time, I didn't have that kind of thing. That's not a legal objection. Is this a misrepresentation of your property at a particular time? Even if you object to what day and time that is, and you object to
It's essentially a legal issue if people are trespassing on my property.
Ms. Keller?
Your Honor, I don't think this is a legal objection. I think she's raising issues that, one, were not disclosed prior to hearing pursuant to the quasi-judicial rules, but she's not stating any sort of governing law that would keep this out of evidence.
I would agree with that. So your objection is overruled. It is admitted into evidence. You can still cross-examine about those things that you object to.
I am a little curious about her question. I mean, what she's objecting to. I mean, she's saying that she wasn't there at the unit when these people went in there and took pictures. That is troublesome. There's something that has to be figured out there. But objecting to this picture going into evidence the way that she's doing it doesn't work. But yeah, how did the people get into the apartment to take pictures? We need to come to the bottom of that one.
I have another objection about it.
What is that?
I don't believe that it's relevant to the reason that I was receiving the fine.
Well, this would have been taken before you received your fine.
Yeah, but the fine of non-compliance was due to the issue of no interior door. It wasn't due to the issue of the kitchen being non-compliant. That had been resolved much earlier.
So what you heard from the witness when he testified is that it was brought to his attention in part for the kitchen. So what's in evidence right now is that the kitchen was potentially an issue. So I'm going to overrule that objection as well.
I do have another objection to it. I believe that the rules on the website around what's allowed in a short-term rental licensed kitchen is not that explicit enough to make.
That is a different issue. It needs to be, your objection needs to relate to some reason that this picture is not a fair and accurate representation, essentially, of the interior of your unit at a given point in time. You can argue about, or you can cross-examine him later about what that given point in time is.
Okay.
But with respect to the picture itself.
Okay.
Okay, so as I said previously, the Exhibit 1 is admitted. Go ahead, Ms. Keller.
Thank you. Mr. Neffick, on your visit that day, can you explain to the court what needed to be done to the property to bring it into compliance?
Yes. Remove the cooking appliances, as I said, the induction stovetop and the toaster oven, and then also to create an internal connection once again.
And when you say internal connection, can you explain what that is in plain language?
Yes, it's creating a connection between the main dwelling unit and this additional unit, the separate unit. So it's all one dwelling unit.
And since that first visit, have you checked to see if an internal connection has been made?
Yes, the second visit we had, it was Jen, Ross, and I, my supervisor, and that was July 10th. And the cooking appliances had been removed, and but there still was no internal connection.
Mr. Nefik, what is a declaration of use?
It is a document that is recorded for future use for future owners to provide status and legal use for that property.
The declaration of use applies to the homeowner who signs it as well, right?
Yes.
Okay. During your investigation of 1945 Kohler Drive, did you?
No, I think what they're saying is she's not allowed to have, like, she got kind of built a unit into her dwelling, and there's not a connection to hers. So I think they're saying she has to create a connection between the unit that she put in and her and what the primary unit. So it sounds like she built an Airbnb inside of her own apartment or house, and that's I think that's what they're saying. I don't know exactly, but that's what I'm getting from it.
Look to see if the declaration of use had been signed for this property,
On my first visit?
or just in your general
Oh,
investigation.
yes.
And were you able to find a declaration of use?
Yes.
Where did you find it?
We found it attached to in the records of what we call EnterGov, which is our software.
I'm going to share my screen again. I'm showing you what has been marked as Exhibit 2. What is this?
Number 2 states the owner agrees to remove any physical.
Sorry. Just looking at the exhibit, what is this document?
This is the declaration of use that we just spoke of.
Okay. And is it a fair and correct copy of the declaration of use you found for 1945 Kohler Drive?
It is.
I'm going to move for admission of Exhibit 2.
Ms. Kohler, any objection to this document coming into evidence? No. All right, the document will be admitted.
Mr. Nefik, can you read?
Yeah, I have an objection. They drafted this document when I wasn't home. Objection.
Number 2 on the declaration of use for the port.
The owner agrees to remove any physical separation between the former ADU and the balance of the unit is applicable to come into compliance with the Boulder Revised Code as a detached dwelling unit.
And can you read the name of the person who signed that document?
That would be Julia Panko.
And finally, can you read the address on the upper right-hand corner?
1945 Kohler Drive.
I object. I have an objection around reading number 2. I think it's.
So the document is in evidence.
Yeah.
You didn't object to the document
I
itself.
don't object to the document. I object to the reading of number 2 because it was partial and left out a crucial clause in the document.
And it's something I'll look over myself because the entire document is in evidence. So it would be something that I would look over myself. You can also on cross-examination ask him to read the rest of it. Yeah. Go ahead, Ms. Keller.
Thank you, Your Honor. Mr. Nefik, based on your training and experience, what does the declaration of use mean for the property and for Ms. Panko?
It specifies that there is intent of taking care of the issues that are attached to this property in order to become or get into compliance.
Is it your understanding that Ms. Panko agreed to remove, to create an internal connection to the property?
It is.
Mr. Nafik, what did you do after finding out that the unit was not compliant with the Boulder Revised Code?
That's when we sent a notice and order.
And when did you issue a notice and order for this property?
That was June 30th?
Of this year, 2025?
Yes.
Share my screen. I'm showing you what has been marked as Exhibit 3. Do you recognize this document?
Yes, that is the notice and order.
And how do you know that this is the notice and order that you sent to 1945 Kohler Drive?
We wrote this document and sent it to her.
And is this a fair and accurate copy of the notice and order that you sent to 1945 Kohler Drive?
Yes, it is.
We're going to move for admission of Exhibit 3.
All right. Ms. Panko, any objection to this document coming in? Evidence? No? Okay, it is admitted. Exhibit 3 is admitted.
And Mr. Nafik, what part of the Boulder Revised Code did you cite on Ms. Panko's notice and order?
That would be the Title 915-1.
And why did you cite 915-1?
It deals with having a legal dwelling.
And you issued this after the kitchen was modified, is that correct?
Yes, that's correct.
So what issue did that leave?
That left the issue of the no longer having an internal connection to the main dwelling.
After you issued the notice and order, did you converse with Ms. Panko about her property?
Yes, I sent an email July 2nd, I believe.
And was any sort of compliance agreement proposed to Ms. Panko?
Yes.
What agreement was that?
This is actually after the notice and order was sent, so it was to reestablish an internal connection.
And what was the result of that agreement?
She had agreed in the email sent back that she would do it.
And approximately when was that?
I believe it was the email sent back. It was fairly shortly afterwards. I don't recall the date.
Mr. Navik, I'm going to show you what has been marked as Exhibit 4. Do you recognize this document?
Yes, I do.
What is it?
This is sent to both Jen and myself from Spanko on which she is.
Hey, Pastor Dragon, thank you so much for the 19 months. I do appreciate it. That is awesome. Just had to take a little break. Okay, break's over. Let's go.
Going to do from a list of options that Jen Ross had sent to her earlier.
And a list of options for compliance?
Yes.
And is this a fair and accurate copy of the email you received from Ms. Pinko on, looks like August 7th, 2025?
Yes, it is.
We're going to move for admission of Exhibit 4.
All right, Ms. Panko, any objection to this document coming in?
No.
All right, Exhibit 4 is admitted.
Mr. Navik, can you read the first 2 lines of this email for the board? I can zoom in if it's a little bit small.
Of the options, what makes the most sense to me is to reestablish an interior door to have the house become a single family residence and to continue with short-term rental. That is what I plan to do.
And after this email was sent, did you come back to see if that interior door was reestablished?
No, I did. Well, actually, I did. That was my third visit, and nobody was home. So I wasn't able to see whether that had been established, but unless there's a surprise, I don't think it has.
Did you ultimately issue a notice of agency action to Ms. Panko?
Yes, I did.
And why did you do that?
Because a date was given, 30 days from the notice of order to apply, or at the very least, submit a permit, but nothing had happened. So I sent the notice of agency action define.
So no proof was submitted within 30 days that the interior door had been reestablished?
That's correct.
And you didn't see any evidence of efforts made to begin the process of reestablishing it?
That's correct.
I'm showing you what has been marked as Exhibit 5. Do you recognize this document?
Yes, I do.
What is it?
It's a notice of agency action.
And is Exhibit 5 a fair and accurate copy of the notice of agency action you issued against 1945 Kohler Drive?
It is.
I'm going to move for admission of Exhibit 5.
All right, Ms. Panko, any objection to the the notice of agency action as Exhibit 5 coming into evidence?
No.
All right, Exhibit 5 is admitted.
Mr. Nabik, did you ultimately issue a second notice of agency action to the property?
I did, yes.
And why did you do that?
The notice of agency action, besides finding for not taking care of the violations from the notice of order, gives an additional 30 days in order to comply, and 30 days had passed.
So within those next 30 days, you didn't receive any evidence that Ms. Panko had reestablished the interior door as required by the code?
No, I did not.
And you didn't receive any evidence that she was attempting to get a permit and start that process?
That's correct.
You recognize this document? I'm showing you what has been marked as Exhibit 6.
Yes, this is the second notice of agency.
And is this a fair and accurate copy of the second notice of agency action you issued against 1945 Kohler Drive?
That's correct.
I'm going to move for admission of Exhibit 6.
Ms. Panko, any objection to Exhibit 6 coming into evidence?
No.
All right, Exhibit 6 is admitted.
Mr. Nabik, is it your understanding that as of today's date, not all of the issues agreed to by the appellant in the declaration of use have been resolved?
That's correct.
And as of today's date, you still haven't received any evidence that the property is in compliance with the Boulder Revised Code?
That's correct.
Has your supervisor received any evidence?
No, not that I'm aware.
What will happen to the code issues if the property is sold before the current owner achieves compliance?
They follow the property. So if this the internal connection is not reestablished, the new owner will have to reestablish it.
Thank you, Mr. Nabik. I don't have any further questions.
Okay, give me just a moment to finish my notes, and then it'll be your turn, Ms. Panko, to cross-examine the witness.
All right, real quick. Lizette, thank you so much for the super chat. I appreciate it. Colin, I just wanted to wish you a happy new year. Thank you, Lizette. You too. Thank you. Happy New Year to you as well. And then Phil coming in with 10 gifted memberships. Thank you so
Ms.
much,
Panko,
Phil.
it is your turn to ask questions.
Welcome to the 10 new members, Phil. That is awesome and very generous of you. Thank you.
Of the witness.
I do have a question. Who met you at the house and was home when you visited on June 30th?
The moment I said June 30th, I was thinking, was it June 23rd? But it was Carrie Schwartz, or is that her name? Carrie? Cindy Schwartz?
I don't believe that anyone was at the property.
Jack, this is testimony. She can certainly ask questions during this
Yeah.
time.
You are testifying, so you're just asking questions at this point. When it's your turn to present your case, then you can
Okay.
testify.
So
Okay.
then my question was, who met with you?
I believe her last name was Schwartz. And she was there as your housekeeper who was dealing with the recent flood. And so we knocked on the door. She answered it. We asked if you were home. She said no. And we got to talking, and we asked if we could see the bottom unit, and she was more than willing to allow us in.
And did you make any communications with me about that visit?
I did not, but she let us in.
Yeah, I can do my best. So for everyone that came in late, this is a landlord of sorts. It sounds like she's made an Airbnb, is what it sounds like, and it's against the code regulation, something. It's against some kind of code in Boulder, so she's getting in trouble for it, and she was supposed to fix it. It sounds like she didn't fix it, or at least that's what the prosecution is trying to prove, that she did not fix it. And I don't know if she's still renting the unit out or not, but she is going at this pro se, and she's got some decent questions and concerns, but she's not a lawyer, so it's coming across kind of cringy. But it sounds like the biggest issue in her unit, or in what she's trying to do, is the whatever rental property, that unit that she created. The code enforcement is trying to say they need a connection between the unit and her main residence, because the unit's not in compliance to be a rental unit. So that's what they're asking for. And I guess she hasn't done that yet. Something about a door. I don't know. Something like that. Anyways, it's a mess. That's what we're going through. It's a long one though. We're going to be here for another hour and a half, probably. So let's go. Hopefully that helped. Probably not. Probably clear as mud and twice as thick. Let's go.
Maybe we could look again at the declaration of use.
Okay, and that is exhibit 3.
2, I believe.
2.
I don't think so. I think, there could be a lien put against her property if she tried to sell it, which is what they just said. She could probably get fined. If she tried to rent it, she wouldn't have a rental certificate. So that would create all sorts of issues, especially if the renters tried to sue her for anything. Yeah. I don't think she can get kicked out though. She owns the place.
Sorry for me to see it.
You're good.
One sec. Okay, I have it on here.
I can
So-
zoom in on anything.
So you had read number 2 up to where it says, and remove the former ADU and the balance of the unit. Could you read the rest of number 2?
After unit?
Yeah.
As applicable to come into compliance with the Boulder Revised Code as a detached dwelling unit.
And what is your interpretation and understanding of the phrase as applicable in this context?
It means that the city doesn't, isn't going to choose where you make that internal connection. And we're not going to be responsible for you picking your designer of where that's going to be. It's applied to you in that case.
Okay. I don't think I have any further questions.
Okay. Based on the cross-examination, Ms. Keller, do you have any redirect?
I don't, Your Honor.
Okay. May this witness be excused?
Yes, Your Honor.
All right, Ms. Keller, do you have any additional witnesses?
No, Your Honor.
All right. This case?
Yes, we would rest, Your Honor.
All right. Just a second. All right, Ms. Panko, do you have any motions to make at this time?
Can you remind me what motions would be?
A motion that they have not, that they have not proven their case.
Yes, I suppose I would.
Okay, and do you have reasons why?
Yes, because information was presented selectively, and there's very relevant information that counters the evidence that they've given, that they do have access to, that they chose not to present. Just kind of selectively show the things that would work against my case.
Yeah, that's your job to do that, though. You can't just say that. You can be like, hey, you showed this part of this evidence. Why didn't you show this part? So let me ask questions about this part. That's how you do that. You can't just say, oh, they only did half the case. I win. Let's go home.
Okay, hang on just a moment. My document has decided to hang up on me. I'm taking notes as we are talking, and my document has hung up on me. I apologize. Give me just a moment, see if I can get it to cooperate.
Yeah, this isn't that big of a deal. I don't think. It's code enforcement, right? They don't want anyone renting her makeshift Airbnb for code reasons. Which, yeah, I don't know. Put up a door just so there's an entryway between the rental unit and your main stay, and that's all she has to do. She had some kitchen stuff, but they said that she took care of those. I don't know. This just seems like a waste of time.
All right, so how the motion you
Dr.
just
J,
made is decided by a court, just so you know.
Dr. JD, thank you so much for the super chat. I appreciate it. Thank you.
We have to take the evidence that's presented by the prosecution in the light most favorable to the prosecution and look at it that way. And could a reasonable fact finder, from what they've presented, could a reasonable fact finder find that there is a case, that they have put enough out there that the fact finder could come to a determination that you had in fact violated? So that's sort of the standard. And I am the fact finder in this case. And based on what they have presented, and I understand you feel like it's presented selectively, but you can certainly show me that if you want to present a case. By that standard, I do find that a reasonable fact finder from what they presented could come to the conclusion that you violated. Now, that's not saying I have come to a conclusion, just so you know, but it's a very, very low burden that they have to meet for this kind of motion that you've made. And based on that very low burden, you know, I cannot grant that motion and dismiss their case. So the case will be allowed to proceed today. And now it's your turn. First of all, if you want to make an opening statement, because you waived it at the very beginning, but you have that opportunity now, if you want to make an opening statement, to tell me what evidence you are going to bring in. But you don't have to, and you can just start presenting evidence if you like.
Can I make an opening statement as a kind of summary without showing documents? That kind of.
It would be a summary without showing documents, but it cannot be.
My reason for countering it is.
Okay, but it's not argument. It's just the evidence is going to show blah, blah, blah.
Okay.
Okay? You want to take a minute? You want to take a minute and think about that?
Yeah.
Try to organize your thoughts? You can certainly do that.
Yeah, I agree. White Hat. They're important. I just don't know why we're going through a trial with this. I mean, especially if she's no longer renting this unit. I mean, she said that she didn't have enough time to fix this, so she's already admitted to the violations. I just don't see why we're having a trial for it, unless she's still renting the unit. If they have proof that she's renting the unit, then sure. But yeah, that's just my 2 cents. All right, let me try fast forwarding. Let's see. We're at 1 hour and 30 seconds.
In October 2023.
Okay. I think we're good here. Bow, bow, bow. Okay, maybe we're not good here.
And can you repeat what you said about a costly remodel? I apologize.
Yeah. So I completed a costly remodel to convert the former kitchen into a wet bar to comply with the single-family dwelling requirements.
Go ahead.
The city inspector in October 2023 inspected and approved the home as a single-family dwelling and removed the ADU status.
Okay.
Following that, the city then granted a short-term rental license to the property, reinforcing that the configuration was compliant.
Okay.
Then, not until I began running the short-term rental business, then I was ordered to shut down immediately without notice of appeal or an opportunity to cure by the short-term rental licensing office. Additionally, I was, that's good. I had no notice that I could appeal the action at that time.
Okay.
When I was doing the remodel, I had requested blueprints of the house and was told that none were available, that they didn't exist. And then only after the enforcement began did the city locate blueprints that had previously been represented as unavailable. those blueprints.
Are you waiting on me?
Yeah.
Oh, sorry, go ahead.
Okay, so those blueprints were used to assert that an interior door had once existed, despite the remodel being completed in reliance on city approval and missing records. So compliance at this point would require the destruction of the newly built code compliant wet bar at substantial cost. And the current illegal ADU status and penalty resulted from city cause, reliance, inconsistent enforcement, and lack of
Your Honor,
due
I'm gonna
process.
object. This
Heather is doing great today. She was in chat a few minutes ago. Maybe she'll jump back in. She might be lurking. I don't know. She's great.
is argument.
So that part is argument.
Okay,
Sustained.
all right.
Java Puppy. Very generous super chat. Thank you so much. The Narwhal got a hold of my Cheshire card. Well, thank you, Narwhal. Thank you, Cheshire card and Java Puppy. That is awesome. Thank you. Happy New Year. Let's go.
Another thing, but it might also be argument. I'm not sure.
If you think it's argument, it probably is. If it's a statement of alleged fact, this happened, that happened.
I was informed in my meeting with Chad that as applicable, which was read earlier, had actually to do with whether an interior door had previously been present in the property.
I'm gonna object to her talking about her meeting with Mr. Navik here. She certainly had the opportunity to ask someone questions related to that meeting, but nothing has come up in evidence related to that specific issue.
Given that the witness is still here in the courtroom, I agree with what you're saying, but of course the rules of evidence do not strictly apply to quasi-judicial proceedings. So given that the witness is still here, she can recall him for her case and ask about that. So I'm gonna.
That's appropriate.
What's that?
Would that be appropriate?
Yes, he's still here and he can be recalled.
Okay,
Had he left, it might be a different story, but
then I'll call Chad Navik.
are you done with your opening statement?
I would assert that, yeah, I don't know how to say it, it's quite complex. I think
Say it
when I
in-
get the chance to present documents, I think my intention will be more clear.
Okay. So as far as opening statement, you are finished.
Yes,
You have no more facts that you want to tell me about that you believe will come into evidence.
yes, but they're attached to documents that,
You can still talk about them if you
Okay.
think those documents will come into evidence.
yes. Then I had earlier guidance from the city at the time of the remodel, where I was sent a list of the things I needed to do to be compliant that did not include creating an interior door between the spaces.
Phil, thank you so much for the generous super chat. I appreciate it. The narwhal gave the card to the squirrel. I believe it. I believe that pesky narwhal. Anyways, Phil, thank you so much. That is generous of you.
And I believe there's an inconsistency.
Your Honor, this is
Between-
argument, her believing that there's an inconsistency.
Sustained.
I, well, I'm going to present, document that where it was agreed that my home was changed to a single family residence, as well as my short-term rental license that was issued.
Okay. Okay.
I'm just gonna check one more time. I think that's everything.
Okay. Now, it sounds like you have, you want to call Miss, I'm going to say your name wrong, sir. It's Napchek?
It's close. Napping.
Napek. I'm so sorry.
It's okay.
All right, so you want to call Mr. Napek.
Yes, I'll call Mr. Nutbuck.
Okay.
Thank you.
So, Mr. Napek, you are still under oath, sir?
Yes.
So it's direct examination. You can ask him whatever, and then again, once you are done with his questions for him, Ms. Keller will have the opportunity to ask him questions
Okay.
based on what you're asking.
All
Even though
right.
she's already asked him questions and you've already asked him questions, now you're presenting him as a witness in your case,
Okay.
if that makes any sense. Go ahead.
Yes, I think so. So, do you remember when you visited and we spoke at length in the apartment and looked through blueprints and all of that? Is that also your recollection that we looked at blueprints and discussed the issues? of the
That
second
was
visit?
with Jen Ross, correct?
Yeah.
Yes. Yes.
So do you remember at that time discussing the importance of whether an interior door had previously existed?
I don't recall whether that was brought up at that time or not. I just don't recall that conversation as well as you.
Okay. You remember mentioning that the city undertook a 2-week search in order to locate the blueprints on microfiche?
I don't recall if that was brought up at that conversation. Was it?
Yes.
Regarding are you talking about the Harburger?
So you're asking her questions.
Oh, okay.
If you're
So
saying.
I don't know. I don't recall.
What you're saying is you need more information.
I do. Yeah, I need
Okay.
more information about the blueprints you're speaking of. I don't know what those blueprints are.
You don't recall that you actually brought them to the house and presented them to me?
Oh, well, Jen Ross, she must have had those blueprints. But I don't recall. I know of different plans from from 1945. I don't recall which blueprints she brought with her or with us.
Do you recall looking around the space and trying to figure out where there may have been a previous interior door?
I know after the fact where it used to be, but at that time, I don't know where it was. When we were meeting, I don't know, although I do know she discussed it with you, but I don't recall exactly where it was.
So would it be fair to say that you don't recall much of that meeting?
I do recall some, but not specifically what where that internal connection was.
Do you remember why we were discussing that?
Yes, because we do know that at one point there was an internal connection, and I know where that internal connection was in the beginning.
And why would that have been relevant?
Because it could be helpful to where it could go in the future.
So do you have any recollection of the part of the conversation involving an exemption to homes that hadn't had previously had an internal connection?
Could you rephrase that? Could you repeat that?
Yeah.
That's the proper way to do it. Thank you.
Do you recall part of that conversation involving looking for an interior door on the blueprints and in the home because properties that didn't have an interior door previously were potentially not required to have one because of the way the law is phrased as applicable?
This home had a legal ADU back in 2013. And what happened is it did not have an internal connection. So prior to that, at some point, it did have an internal connection, but somebody made the choice of making that a separate unit. As of right now, it can be reestablished as an ADU legally, or to make the internal connection.
That didn't really answer the question that I asked.
Do you want to repeat that question?
Yeah, repeat the question.
It's a long question.
Repeat the question. Let me phrase it this way. In my memory, we discussed at length the idea that a property that had never had an internal connection.
Your Honor, this is testimony. This isn't a question.
I guess that's where
I had discussed this.
I'm going to allow it.
About in her memory is her own testimony, not asking a witness a question. She can certainly testify under oath about her memory, but her asking a question should be a question.
It was the question.
I will give you a little leeway. It is to some extent testimony. What I won't do is take it as such, but it sounds to me like you're trying to orient him to a particular
part of the conversation. Yeah.
So I'm going to allow it for that reason. I'm not taking it as evidence in the case unless and until you testify to it later. Does that make sense?
Yeah.
So what your memories are right now are simply to orient him. It's not evidence I'm going to consider. You can testify
if he remembers discussing something.
Yes. It's all I'm saying is the part where you're saying it's my memory that you are essentially testifying, but right now you are not the witness. So you can, if you say that now, I'm not going to count it as evidence in the case because you are not sworn as a witness right now. You're not testifying right now. You could repeat it later when you're under oath if you are going to testify, and then I would consider it.
Okay.
But I understand you're trying to orient him to a particular part of the question. Go ahead.
I'll phrase it differently.
Okay.
Do you remember discussing section 2 in the declaration of use when we met?
Yes, I do.
Do you remember part of that conversation being the concept that as applicable would apply to an ADU that had never had an existing connection?
I do. However, I also recall Jen, which I was there, said that because, as you believe, there was never an internal connection, doesn't make it compliant as it is right now. as I said before, and I think this probably was in the conversation as well, is that it was a legal ADU. You came in to purchase the property, and you were given the choice to keep the legal ADU, but you chose not to because you wanted short-term rent. Do you remember that?
You're asking her questions.
Well, okay, it seems like a conversation suddenly, but it's not.
It's not. It's not a conversation, and that's something that Ms. Keller can follow up with.
Yeah.
So you can just testify to what you remember occurring.
And hopefully I did.
All right. I don't know why I did this an hour and a half into this video, but I just looked up what an ADU is. It sounds like the owner, it sounds like she made a terrible mistake. With an ADU, you can rent a unit. So it's an accessory dwelling unit is what an ADU is. Yeah. I don't know why she would have denied that and tried to go for a short-term rental. I don't know what the difference is, though. Yeah, maybe I should have looked into that before saying anything. Okay, let's go.
I have no further questions.
All right. Ms. Keller, your witness.
Mr. Nafik, are there any parts of that conversation that you wish to clarify for the court?
I don't recall a lot of it. There were two of us. Jen, my manager, seemed to be talking and clarifying this whole issue, and I probably wasn't as observational as I probably should have, but because she was taking care of it. So that's, in honesty, that's probably what happened.
Is it relevant to this proceeding that there was an interior door at some point in this home?
It is.
Why?
It is because, as we've been speaking at length about, is the declaration of uses that Ms. Pankow signed, that she would take care of the issues of removing the cooking appliances, making it into a wet bar, and creating that internal connection. So it is a single family home once again.
In that conversation, did you impart on her the importance of the internal connection?
I think we did probably best we could through emails, the written word.
I'd love to further, Your Honor.
Okay, Ms. Pankow, do you have any redirect based on the questions that Ms. Keller just asked?
I do have one.
Okay, go ahead.
I don't know how to phrase it. 1 second. I guess when you read for us from the declaration of use, number 2 as applicable, it sounded to me like you defined as applicable in a certain way. That wouldn't have made an interior door relevant, and just now you spoke to it being relevant. Is it interior door relevant because if there hadn't been an interior door, there would be an exception made?
The exception made would be that one would have to get the certificate to be a legal ADU. So it could be separate. It could be attached or or detached. However, if one doesn't have that permit or certification for a legal ADU, then If it's
And I'm sorry, just to clarify, you're saying illegal ADU or a legal?
illegal.
Okay, just
Yeah,
making sure.
Yeah. Then if it is a separate dwelling unit, which it is, to the house, the main dwelling unit, it does have to have an internal connection in order to short-term rent. I mean, I guess we're not here to tell you, you have to do this, but then you have to go back to getting a legal ADU. You have to get that permitted. So, but then you can only long-term rent.
No further questions.
Recross based on that?
No, thank you.
All right. May this witness be excused again. Okay. I said, hold on just a moment. May he be excused?
Yes.
Yes, Your Honor.
Thank you. You're excused, sir. All right, Ms. Panko, do you have any other witnesses?
No.
And that would include yourself. Are you
Oh, yes.
pending on testimony?
I would like to be a witness.
Okay, then what I'm going to do is swear you in. I'm going to allow you to testify from where you're seated rather than have you come up to the bench. Actually, no, come up to the bench because she needs to cross-examine you.
Actually, let me ask questions about that. Is
Go ahead.
myself as a witness only to answer questions to the
No,
prosecution, or can I ask questions of myself?
Well, you wouldn't ask questions of yourself. It's a little different when you are your own witness without an attorney. So you would simply tell me what you want to tell me in narrative form. Of course, confining it to relevant issues. You've got a lot of documents to present. I'm not sure that many documents based on what you've said would be relevant, but we'll cross that bridge when we come to it. But you're allowed to testify to the documents, what they show, that sort of thing. But then Ms. Keller is able to ask you questions, both of the things you say with and without documents.
Yes, I would like to do that.
All right, so come on up. You can bring your computer with you. And then, Ms. Keller, are you able to assist her with documents?
Your Honor, I can certainly put stuff, I can try. I just want to make sure in the interest of fairness, since I'm viewing these for the first time, I also have a fair opportunity.
Right, so as she introduces each one, we'll stop the proceedings and afford you the opportunity to look at it. And if I forget to do that, please stop me.
Okay.
And then actually our clerk who is listening.
I am listening. I'm not sure if you can hear me, but
I can hear you.
And
So since do you have all the documents uploaded with proper letters?
I do, ma'am.
All right, then I'm going to ask you actually to list the documents.
Absolutely.
Or show the documents, if that makes any sense.
Yes.
Okay. Thank you. All right, Ms. Pinko, I do need to swear you in.
Okay.
So I need you to raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. You may proceed.
So can I present various documents?
Yes.
Okay.
But do them one at a time. And again, because Ms. Keller did not have the opportunity to review them ahead of time because you didn't submit them ahead of time, tell her which one you want to look at first. She's going to get the opportunity to look at it.
Okay.
And then once she's had that opportunity to review it, then you can discuss it and then you can ask that it be entered into evidence. She will have the opportunity to object just like you did. And I will make a ruling. Okay?
Yes.
All right.
Yeah, I don't need to bring up too many of them, actually. I think I included more than, I didn't understand everything. I included more than I needed to. But,
Okay, so the other thing is, why don't you refer to them as whatever number you have, and then I will have our court clerk clarify what letter that's going to be.
Okay. I need to find document. Well, I could start by saying something about the declaration of use that we looked at earlier.
You can certainly say something about it. That document is admitted into evidence,
Okay.
but it can't be argumentative. Right now, you're just presenting facts. Argument does not come until the end.
Okay,
You can point something out that is factual, then you can,
I'm gonna try to do that.
then at the end, you can say why you
Hey, Graham, enjoy your hike. Sounds awesome. Sounds awesome. Have fun.
pointed that thing out and how it's a problem for the prosecution. Does that make sense?
Yes.
But not now, just present factual things.
Okay. So, I want to say about the declaration of use,
And that's exhibit 2.
Exhibit 2. That in the second clause, the term as applicable could lend itself to various interpretations.
That's argument.
That's argument.
That's argument. You can simply point out that it says as applicable. Later,
I want to
you
point
can
out-
talk about what that means.
Thank you. Sorry.
Okay, that's fine.
Prepared better.
That's okay.
Yes, that as applicable. It does say as applicable in that clause.
Okay.
Okay.
Are you ready to move on to another document? Or
Yes.
did you have something else? Okay, go ahead.
One. Okay, the one that's numbered exhibit 8.
Okay, exhibit 8, and you have the numbers, Ms. Keller. So you look at that, and if the clerk could find the one that was numbered exhibit 8.
Yes,
And can you
ma'am.
tell us what that document is so we can make sure to locate it properly?
Mhm.
Yes, it's a permit from City of Boulder. Across the top it says permit number, BLD, SFD.
That's the 2023.
Yeah, 2023.
And Sabrina, our clerk, can you tell me what letter that is?
I believe the one that is being referred to is Exhibit I in ours.
Okay.
Although I heard a 2023, so that might be a little different.
Hold on. Let's make sure we get.
Yay, News Now. Thank you so much for the 2 months. I appreciate it. Thank you. Happy New Year to you as well.
That oriented here.
If it is something with the number 2023 in there, it's actually going to then be Exhibit G.
Exhibit G.
If it has the permit number at the top, and if that is what is being referred to, then that's what I see.
Random New York lawyer. Thank you so much for the 9 months. I do appreciate that. That is awesome. Good to see you and Happy New Year.
So just to clarify with you, Ms. Panko, this looks like a screenshot to me.
Yeah.
And it's at the very top left, it says permit number BLD SFD 2023-00168.
Correct. Yeah.
Okay, and that is exhibit
G.
G. Thank you. All right, go ahead. Well, sorry, actually, let's check in with Ms. Keller. You've had a chance to review it?
I have, Your Honor.
Okay, go ahead, Ms. Panko.
Okay, so
Now, you shouldn't be talking about what it says. What you want to do is identify what it is. If you want it considered an evidence,
yes,
you can identify what it is. You have to state whether or not this is a fair and accurate representation of the permit. And then you ask that it be admitted.
Okay.
And then Ms. Keller will have, you also have to state how you know what it is, how you know what it is. Is it a fair and accurate representation? Then ask that it be admitted. Ms. Keller will have the chance to object just like you had the chance with respect to her documents. Then once it's in evidence, you can talk about what's in it.
And
Okay.
Your Honor, And Your Honor, sorry to interrupt. I just wanted to know, should I be sharing this right now with you, with you all?
That would be great.
Okay.
Thank you. All right. So go ahead. Tell us what it is.
This is a permit describing the transition of the former ADU into a single-family dwelling that was issued when an inspector came to the home and just decided that it met the criteria to be converted into a single-family dwelling.
Okay.
And I found it on the city's websites where they list all activity of permitting. I can't remember exactly where that is, but it was like the.
And how do you know that that's what this is?
Because I went online myself and located the permit.
Sorry, I meant, how do you know that not where you found it, but that the permit is what it quote unquote purports to be? Is this a permit you applied for?
Yes, I applied for it. An inspector came to my home like the day before this, examined the home, told me I met the criteria for single family dwelling, and then issued this permit.
And does it fairly and accurately represent the permit that you were issued?
Yes, it's the exact permit as it exists in the city records.
Not asking exact as it exists in the city records. Is it accurate as to what the permit that you were issued?
Actually, there is one difference. It says a hold currently exists on this permit at the top, but that's because I screenshot it just recently for this trial. At the time, there was not a hold on the permit.
Okay, that is perfect. Thank you very much. And are you moving to have this document in evidence?
Yes.
All right, Ms. Keller.
Your Honor, I have two objections. My first objection is relevance. This permit says it was finalized in November of 2023. I'm not sure how a permit that was applied for over 2 years ago is relevant to the issue we're deciding today, which is a narrow focus to see if a notice of violation about the property should be upheld. And my second objection would be a hearsay concern. It looks like there are two people, Brian Holmes and Tracy Harris, who might have authored the description and additional information about it. Ms. Panko certainly could have called those people to testify to authenticate this document. But as of now, we are trying to, I would assume her intention is to admit the description, and that would be an out-of-court statement intended for the truth of the matter asserted, which is the definition of hearsay.
Okay, so Ms. Panko, what she's arguing is that under the strict rules of evidence, you could have called somebody else in to authenticate this document. And it looks like two other people. I'm not seeing that on the document, Ms. Keller.
It's at the bottom, Your Honor. They're under the green zoning review.
Oh, I see it now. Okay. I do see it now. So she's basically saying because you're offering it for the truth of the matter. In other words, what is in this document, what this document says is true, that the document itself, that stuff has not been sworn to in a court of law. So it's what's called hearsay. And under the strict rules of evidence, hearsay is not admissible. Let me ask you a question on what is the purpose of admitting this document? Because another objection she made is it's not relevant to what we're here to discuss today.
I mean, it's incredibly relevant.
Why?
It's relevant because the inspector came to my home and told me that the home was now a single family dwelling, which is completely counter to what I'm now being fined for. And this is a permit that doesn't expire until 2026, so it's still active.
Your Honor, what she's saying the inspector told her is not contained anywhere in this document.
And that would be correct. It's not contained in the document. So that is most definitely hearsay because that person is not here. That said, I
think it does say at the bottom that the zoning review was approved by Brian Holmes.
Right, and her other argument is it's hearsay and you could have called Brian Holmes in to say what this document says. That this document says that Brian Holmes approved it, but that's an out-of-court statement being offered for the truth of that matter, the fact that Brian Holmes approved it. So I want to try to be as fair to you as I can, certainly not understanding the rules of evidence. And this is going to sound weird, but it's in a way, I'm asking you to make a little bit of argument to me in terms of give me more. I've heard the testimony that you were approved for a single family home, and now you're being told that this interior door has to be put in to make it a single family home. Yeah. So very briefly, I need to know why this is relevant. Why is that important?
It's relevant because I was reliant on guidance from the city throughout the process of making changes to my home to make it into a single family dwelling. And I feel that the guidance and information given to me has been inconsistent and sometimes partial, like in information that wasn't provided to me earlier on was then used to come against me legally. And I don't feel that that's fair to me. I don't know how to say that better.
Okay,
but
that's what I need to know.
Yeah, including this document.
All right, so what I'm going to do.
Two other documents in here as well.
What I'm going to do is admit it. I don't know how much weight I'm going to give it. Okay. So I'm not promising to give it the full weight of every single statement made in the document is true. I will let you admit it for the purposes of, the case you're trying to present.
Okay.
But I'm not necessarily going to give it the full weight.
Okay.
So that document is admitted. So that's Exhibit G as in golf. Go ahead.
And the document that says Exhibit 5 on the video.
All right, Sabrina's going to bring that up for us. And can you describe what Exhibit 5 is?
Yeah, it should be City of Boulder Planning and Development, rental housing licensing. Property number RHL 01001892.
All right, so our document just appeared on the screen. That's a declaration of use, Sabrina, so that's not the right document.
It's the one just before that.
Is this the right document?
Yes.
Okay, go ahead. Well, actually, wait a minute. Sorry, Ms. Keller. You've seen it? Great. All right, go ahead, Ms. Panko.
So this is a rental housing licensing for property number RHL 01001892, which is at 1945 Kohler Drive. This became effective on August 21, 2024 and expires in 2028. And it's permission to short-term rent the property.
Okay. Are you trying to, again, you've got to, how do you know?
I'm trying to say that
is it fair
this is
enough?
relevant because this.
We're not there yet.
Okay.
We're not there yet. So you're saying, okay, you've described the document to me. How do you know that the document is what you're saying it is? Did you?
Well, the city sent me a formal paper copy and also emailed it.
You recognize it?
Yes,
Okay. And is it a license you applied for?
yes, it's a license I applied for.
Okay. And is it a fair and accurate representation?
Yes, it's an exact copy.
Okay. So what I'm going to ask you to do, I'm going to ask you to take a note and write down these questions because I'm sort of guiding you, but it's going to be up to you after this about what you need to present.
All right.
All right. So what is the document?
Okay.
How do you know? Is it a fair and accurate representation?
Okay.
And then you move to admit.
Okay. All right. So have we answered the first three thus far with this one?
I have not heard an objection.
Okay.
So,
I move to admit it into evidence.
okay, Ms. Keller.
Your Honor, the city's going to object to relevance. What we're here to decide today is an alleged building code violation brought under section 915.6 of the Boulder Revised Code. This isn't a licensing issue. There's nothing.
I'm going to overrule the objection because I just told her what to do. What do you mean? You're saying that what I said is not relevant? I mean, at this point, the attorney's objecting to what the judge is saying. Oh, let's go.
In this document that talks about that specific issue. So I'm just not entirely sure the purpose for which it's being admitted.
So you can now argue why it's relevant, or not argue, but tell me briefly why it's relevant.
It's relevant because of inconsistent information from the city in terms of receiving permission to short-term rent and being essentially told by receiving this license that my property was compliant to rent, and then having legal action taken against me for short-term renting.
Right. So Ms. Keller, let me ask you this. Understanding that the issue is whether or not she has violated the code, it's your position that the fact that she has, and let me back up, violated the code and specifically violated the code with respect to using the property as a short-term rental, but that she also has a short-term rental license, you don't believe that's relevant?
Your Honor, the issue here is the need to establish that internal connection. This isn't a rental licensing action. It's also my understanding that this license, even if it did exist at one point, was revoked. So maybe it was issued, but I don't think it's relevant to what we're deciding here.
So again, in terms of relevance, would you agree that if she was issued a short-term rental license, the city had approved it for short-term rental without this internal connection, and then now the city is coming back and saying you have to have an internal connection, that's not, those two things do not connect? Just trying to clarify.
Yeah, I think, Your Honor, what you're asking me about the process that leads to someone being issued a short-term rental license. And to be perfectly blunt, I don't know exactly the steps to those processes. I would be happy to call Kimberly Barnett as a witness on another day to talk about that. But for purposes of this hearing, it was my understanding that that's not what we're here to talk about, why she was granted a short-term rental license or not. But the property as it stands currently, it's the city's position that it's not a code compliant property, which has health and safety issues.
Okay. All right, again, I'm going to admit it. I am reserving for the moment whether or not it's relevant as we get further into what you have to tell the court. So I don't know how much weight I'm going to give it, but it is admitted for the purposes of this hearing. Weight is to be determined. All right, go ahead.
Okay. The document just before that, just about that one.
Okay, so what would be exhibit 4? And I'm sorry, Sabrina, what is the letter associated
Yes.
with? Oh, it's E, I see.
Yeah,
I see
it's
up in the
exhibit
corner.
E. Mhm,
Thank you.
mhm.
And so the next one will be the one just before this, so exhibit 4.
Yeah, it starts with message about request.
Okay.
at the top.
And give me just one moment and I'll pull that one up.
Sorry, which exhibit is this?
It's going to be the number 4, apparently.
It says exhibit 4 on the PDF I sent you. And it begins with message about request. It's number 1158.
I found that one, so give me just one moment. Is that the correct
Yeah.
document? Okay, and that would be exhibit D.
D is in dog.
Mm-hmm.
Great. And Ms. Keller, have you had a chance to review it?
I have, Your Honor.
All right, go ahead, Ms. Panko.
Okay. So this is email that I received from Lisa Hood, the senior city planner. We were talking in March of 2023, and I was planning the remodel. It's her advising me on what needed to happen in order to convert what was the ADU into part of a single family dwelling. I know that that's the case because she emailed it to me in response to questions I had sent to the city planning and development. It is.
All right, guys. I've got a full confession to make. I want to be transparent and honest with you all. I just walked away for about 5 minutes. I made myself a drink. I was like, I'm gonna go make myself a drink. I need one to finish this stream. Yeah. So, cheers. Cheers. I didn't really drink yesterday. So, Heather and I made it to midnight, but we didn't really drink. So, having a drink today. I had a couple beers earlier. So, yeah, made myself a real drink. So, let's go. Cheers.
Fair and accurate representation. It's a screenshot of the conversation we had.
Okay.
And do I name its relevance? It's not really in the questions here.
No, that's not an issue. It's assumed to be relevant unless somebody objects. So,
Okay, I move to admit it.
All right, Ms. Keller.
Your Honor, the city objects first on the grounds that this was not disclosed to us in a timely manner. I think Ms. Panko said earlier that some of the documents were available to the city ahead of time, and that's correct, but this one wasn't. I haven't seen this until now, so it wasn't disclosed within the 10-day requirement. And my second objection is that this document is entirely hearsay. This is all an out-of-court statement made for the truth of the matter asserted by the declarant, who's Lisa Howd. Ms. Panko certainly had ample time and the power to call Ms. Howd as a witness today, and she chose not to do so. So therefore, I think the city is prejudiced by its admission.
Okay. Do you have a response to that, Ms. Panko? And actually, let me stop you there. So tell me again.
I mean, the city is kind of prejudiced against this entire hearing. The judge is representing the landowner at this point, or unit owner. Whatever the building is, the owner. So yeah, I would object to if I were the city.
And what you were saying about it being available or not being available ahead of time.
Yeah, so some of these documents were available to the city, like in her disclosures, like the declaration of use. And I haven't looked through all of them yet. I'm kind of looking through them as they come, but this was a message that was exclusively sent to Ms. Panko, so this was not available to the city.
Okay.
And I haven't seen it until this exact moment.
Okay. All right. So she's saying essentially the city is prejudiced, meaning it's not fair to the city for this to be sprung on them at the last minute when you had a requirement to make your disclosures ahead of time per the rules that you were sent. So ultimately it's trial by ambush, as they say. That she isn't able to talk to this witness. The trial, in other words, we're talking right now. The trial is right now, and she didn't have a chance to speak with this witness.
All right, that's an expensive piece of property. I was about to say, is that normal for Boulder? I don't really know. Is Boulder? I know a lot of areas in Colorado are expensive. I don't know if Boulder is one of them or not. But $3 million, it doesn't matter. That's a lot. That's a lot. So. Yeah, she probably can afford an attorney. Jeez, just saying.
Anything.
Yeah,
So,
I just really didn't understand the process. It's kind of like overwhelming for me, the amount of information and things, and yeah, I get that I didn't do it correctly. I do believe this is very relevant.
She didn't argue relevance. She argued that it's unfair to the prosecution and that it's hearsay that you could have called this witness to testify personally.
I mean, that seems true.
Okay. I'm not going to admit this exhibit.
I mean, that's kind of what I asked earlier, but this is code compliance. It has to do with some kind of code issue about a door. There was a kitchen issue that she says that she resolved. She put in a wet bar, which you might have to add. I mean, you will have to add if you're adding a wet bar is just a sink. That's all it is. I don't know why it became a fancy term called a wet bar, but all it is a sink. Has a faucet. Apparently, you call that a wet bar when it's not, in a kitchen. I don't know. Anyways, someone's gonna respond with the actual definition of a wet bar. Go ahead, that's fine. I lost my train of thought. Oh yeah, code compliance. She needed to put a door in. There was no connecting door between whatever unit she was renting and her unit. So I'm guessing there was just an outside door. Sounds pretty typical to me, but there's something wrong with it where they had to have a door connecting the two. That's why we're here, because of a door.
So you can't talk about anything in it. I do believe that it's prejudicial to the city that they did not have access to this beforehand. Understanding that you, Ms. Panko, hearing what you're saying about not understanding the rules about it, you did have the opportunity to, if you didn't do that, you certainly had the opportunity to ask questions, call up and say, what does this mean? What does that mean? So I am not admitting this particular exhibit.
Understood.
So you need to just skip and go to the next exhibit.
Okay, I'm just checking that might be, I mean, then probably that same argument is going to nullify other ones that I would have presented. Let me just check.
I don't know. I think it's because it's not in compliance to rent it, so they're making her do that. I don't know. But this is Colorado, so I can't even pretend to know. If this happened in Ohio, I could kind of make some assumptions because I know a little bit about how Ohio runs. I know nothing about Colorado, as you could tell by my previous statements.
So it was also email with Kimberly Barnett. Would that have the same problem?
I imagine that Ms. Keller would have the same objection if it was between Kimberly Barnett and you and not a public record.
Yeah.
Would that be accurate, Ms. Keller?
That would be, I'm not totally sure which exhibit we're talking about, but I would assume it was.
She is talking about an email between her and Kim Barnett, I think she said.
Okay, that's correct. Yeah.
And you would have the same objection, and I would have the same response to that. So you can either formally do it and we'll go through the process, or you can decide you don't even want to try.
Yeah, I won't try.
Okay.
That one. Okay, I can enter the document that is on page, says exhibit 22.
Can you repeat what page that is?
Number 22.
22.
Or actually, I'm on 23 is the same thing, but I think probably more clear.
Did you hear that, Sabrina? 23 is a better version.
If I tell you the answer to that, will that influence whether or not you stay till the end or you leave now? Because I can tell you the answer.
See, hold on, let me make sure. Yes, I understand so that what I'm about to put up is going to be exhibit W then, as I understand it. So
I can barely hear you. What you're about to put up is what?
Exhibit W.
Exhibit W is, as soon as it comes up, I'll see if that's the correct exhibit. Is this the correct exhibit?
Yes.
Ms. Keller, let me know when you've had a chance to review.
Just a second.
No problem.
All right, I reviewed it, Your Honor.
All right, go ahead, Ms. Pinto.
This is relevant because I've been receiving these multiple notice of violations from 2 different departments.
Hey, what's up, Katie? Said good to see you. Hopefully you had a great New Year's and Happy New Year. Did I say that right? I think I said that right. That didn't sound right in my head. Yeah, drinking. This is why you don't drink and stream at the same time. Let's go.
And
Okay, so I'm going to stop you there because nobody's challenged its relevancy at this point.
Oh, right. I have to answer the questions. So this is.
Correction, Katie said. This is why I don't drink and stream at the same time. You guys are professionals at it. I'm not.
Is a notice violation from well, it's from Kimberly Barnett. I don't know why that's planning and development, because my understanding is that she's in the short-term rental licensing office. I guess that must be part of planning and development. But this is a notice from Kimberly Barnett of violation stating that I was advertising for a term on a property that holds an ADU. And
oh, that's what I'll do. That's a great idea. I'm just going to stop it about 10 minutes early so you guys have no idea what it is, what she decides on, and then I'll release the ending tomorrow. Then you guys get the best of both worlds. You don't know if it's a delayed ruling or if she rules right away. Yeah.
it is a fair and accurate representation. And I move to admit it.
Ms. Keller?
Your Honor, I do have a relevance objection here. I'm not entirely sure why her being allegedly in violation of section 10.319 is relevant here. I believe that Mr. Knapik already testified that I suppose this was issued and that spurred code compliance to take a look at the unit, but I just don't think it's relevant to the determination that needs to be made today.
Okay. Ms. Panko, why is this relevant?
This is relevant because there have just been ongoing inconsistent information
Okay,
from the city.
that's a conclusion and an argument. Okay. So this is relevant because, and you can state something factual.
This is relevant because at the time that it was issued, my property did not have an ADU. And this says that I was advertising short term on a property that holds an ADU. And this hearing is whether or not the home has an ADU.
Okay.
Your Honor, I don't think this document opines to the conclusion that she's trying to make, which is that this property holds an ADU. It's not talking about the validity of the ADU because that's not Ms. Barnett's role. It is quite clear in the code that any sort of ADU cannot hold a short-term rental license, illegal or legal.
Okay, understood. Understood about your argument, Ms. Keller. As with the other exhibits, I will admit it, weight is to be determined. Go ahead, Ms. Panko.
Didn't that, well, I'll try to admit the very last one doesn't have a number on it. It would be where 24 is. It's the very last document.
Is this the email from Miles Rockwell?
Yeah.
Your Honor, the city has the same objections, which is that hearsay and relevance. This wasn't disclosed to me. I don't know who Miles Rockwell is, and I'm not entirely sure how the apartment repairs are relevant to our proceeding today.
Okay, and so this is a private email?
Yes, that's
Since you've made a formal objection, let's go through the formal process with it. I mean, I will let you know that I am inclined to treat it as the other ones that are private emails and not publicly available to the city. So you can withdraw it or we can go through the formal process.
I'll just withdraw it.
Okay.
And this would be Exhibit X as an X-ray.
Okay, and she has withdrawn trying to present anything about it.
Apologies.
All right, anything else to present, Ms. Pinko?
In terms of documents, no.
Anything to present in terms of what you would like to testify to? Factually, again, not argument.
I guess no. Is there a place where I can make arguments?
Yes, at the end.
Okay.
At the end.
Then no.
All right, so Ms. Keller, cross-examination. No problem.
All right, just a couple questions, Your Honor.
Go ahead.
Ms. Panko, was it your testimony today that you didn't fully understand the term as applicable in the TOU, the Declaration of Use?
No.
You did not testify that you didn't fully understand it?
No.
Okay. So you did fully understand the term as applicable at the time you signed it?
I believe so. I don't think the definition.
Just yes or no is okay, that's all I'm asking.
Well, the definition of it, the chat named is not my
So-
same understanding.
So her questions, you just answer the question and then you'll have a chance to follow up.
Okay,
Everything's it's formal rules of how evidence comes into play. So right now she's cross-examining you, she's asking you questions. You can answer the question as she's asked. So if she presents you a yes or no question, then it's either yes, no, I don't know, something to that effect. If you've got follow-up or you want to give it context, when it's your turn to go again on redirect of yourself, then you can present that. So if you have something you know you want to follow up on, you might make a little note.
okay.
And then when it's your turn again, then you can follow up on that.
Okay.
All right. So did you want to ask your question again, Ms. Keller?
I can do that, Your Honor. So you are testifying today that you fully understand the term as applicable in the DOU.
I guess I'm not sure. I believe so, but I'm not sure.
Okay, so at the time, you may not have understood it fully, your testimony today, the time you signed it.
Yeah, I may not have.
But you never sought any sort of additional guidance to understand that term.
I researched it.
So you did your own research.
Yeah.
But you relied fully on city guidance for everything else, but not for the term as applicable.
No, I don't believe the city explained the legal document to me. They just sent it to me.
But you signed it anyway, is that correct?
I interpreted it as
Just a
reasonably.
yes or no question.
I did sign it.
You did sign it. So your testimony today is that you relied on city guidance to make your decisions,
Yes.
but you never sought additional guidance for a term you didn't understand?
I believe I understood it.
Your rental license was revoked, is that correct?
Yes.
And that was because the city found that your AD was unpermitted?
It's a bit more complicated than that.
So no. Nothing further, Your Honor.
All right. So now, Ms. Panko, it's your opportunity to, just based on the questions she's asked you now, to present follow-up. Can't introduce any new topics, only follow up to her questions, like those things you wanted to clarify. Okay?
So in my own research on the term as applicable, I mean, it's my impression that that's quite a bit open to interpretation because it doesn't say as applicable to what. And in the research I did, it made it, what I found is that it essentially means there will be exceptions to what was stated before. So as in when this applies. And in the conversation with Chad and Jen, which he doesn't remember well, we did discuss at length.
Your Honor, there was some argument there.
There is some argument there. Just
No, I'm not supposed to argue.
not yet. We're not there yet.
Sorry,
That's okay.
I'm stressed.
It's tough. So you were saying your testimony as you were talking about something during this meeting.
Yeah, I did discuss the term as applicable with Chad and Jen when they came to my home. And I did leave that conversation as. That's already. And then the license was revoked. The city stated the license was revoked based on having an illegal ADU. But prior to that, they had issued the home a permit as a single family dwelling. So there's an inconsistency.
Is there anything else you wanted to clarify or follow up on?
No.
All right. Right, so you're finished as a witness, unless, I'm sorry, Ms. Keller, did you have any recross based on that?
No, thank
Okay.
you.
Your testimony is done. Do you have any other witnesses you want to call? So you can go back to the table.
Okay, no, I don't.
All right, so you are resting your case?
I rest my case.
All right. Ms. Keller, closing argument.
Give me just a minute.
Absolutely.
Are you ready, Your Honor?
I am.
Your Honor, the city has proven by a preponderance of evidence today that the notice of agency action imposed against Ms. Panko under Boulder Revised Code 915-1 should be upheld. You heard credible testimony from code compliance specialist Chad Nappick today about the unpermitted ADU at Ms. Panko's property, 1945 Kohler Drive. He has personally visited the property and has seen that this unit is not compliant with the Boulder Revised Code's definition of a dwelling unit because it lacks an internal connection with the rest of the home. He testified that code compliance became aware of this property because appellant sought a short-term rental license without disclosing that she had an unpermitted ADU. When Kimberly Barnett discovered that there was.
Who's this weirdo? What up, Team Skeptic? How are you doing, my friend? Hopefully you had a great night and a great day so far. Yeah. Thanks for stopping by. I got nothing else to say. Just it's good to see you. Hopefully you're well.
In fact, an unpermitted ADU, the license was revoked and code compliance became involved. Per Boulder Revised Code 10-3-19-0, an accessory dwelling unit cannot be rented short-term unless it was legally established by February 1st, 2019. This unit was not. Every permit presented today, like the one appellant introduced in Exhibit G, takes place after 2023. Even if it was established, it still lacks the internal connection. Under Boulder Revised Code 963 N2A specific use standards, it states, if there is an internal connection between the accessory dwelling unit and the principal dwelling prior to the creation of the accessory dwelling unit, the connection together with the lockable physical separation shall be maintained. Your Honor, Ms. Panko claims that she relied on the city, which didn't disclose the interior door requirement. But the most important exhibit in this case is Exhibit 2, the Declaration of Use signed by Ms. Panko and notarized on October 13, 2023. In this document, Ms. Panko acknowledged that this accessory dwelling unit was unpermitted because she agreed to quote, remove any physical separation between the former ADU and the balance of the unit. That is the interior door requirement. She claims here today that she relied on the guidance of the city for everything, but then also claims that she didn't fully understand the document that she was signing. Under Boulder Revised Code 9-15-6, which governs a declaration of use, this document is required to be signed under oath. It gives me great pause that Ms. Panko chooses to listen selectively to guidance and then do her own research on certain issues. Additionally, notice that in Exhibit 4, an email from August 7th, 2025, Ms. Panko told Code Compliance she planned to, quote, reestablish an interior door. She had full knowledge that an interior door once existed in the property. She knew exactly what the requirements are to bring this property into compliance. The city acknowledges that that is an expensive fix. However, lacking this internal connection, that means the unit is presumed to be uninhabitable due to lack of necessary life safety information about the living space. Today, we are asking the court to issue a ruling to hold Ms. Panko to her own promise, the promise she made in the declaration of use and then again in her August 2025 email. That ruling is to uphold the notice of agency action, impose the full $300 fine, and most importantly, require Ms. Panko to remove the physical separation to bring the property into compliance. Thank you.
Okay, thank you very much, Ms. Keller. Give me just a moment, Ms. Panko. All right, Ms. Panko, your turn to make a closing argument.
I do have one question.
Go ahead.
I didn't understand in that closing statement was meant by necessary life safety information.
Oh man, I think this owner has figured out that if she just says I don't understand all the time, then the judge is going to break everything down for her. This hearing only needed to be a half hour long, and here we are, 2.5 hours into the stream. And let's see, we have, is that 22 minutes? No. Yeah, we still have 22 minutes left of this video. Oh man, all right, let's go.
Am I allowed to respond, Your Honor?
Yes, go ahead.
Just a second. In the city's disclosures to Ms. Panko, which were given to her on December 5th, 2025, it talks about Boulder Revised Code 9-6-3N. Let me pull that one. Essentially, Your Honor, it's the city's position that these requirements exist for a reason. They're not arbitrary. They're not put here to make it more difficult, to make Ms. Panko's life more difficult, to force her to spend more money. It's because at some point, people who are wiser than me about building code issues discovered that this was important for the health and safety of occupants in the unit. That's why the short-term rental license was revoked, because without this internal connection, clearly this unit was not safe for people to live in.
All right, are you ready to make your argument now, Ms. Panko?
Yes.
Okay. You can take a minute if you want to.
Okay, mine isn't as organized. I do want to speak to the thing that was just said about necessary life safety information and the unit being unsafe for people to live in, because it was already granted a long-term rental license in the same condition and had tenants there legally. So the city had already deemed it safe for inhabitants. And it's not less safe for people who are there for less nights.
Your Honor, I'm going to object just because Ms. Panko hasn't brought up anything about the long-term license before. And
I think she was just responding to what you said.
It just is completely illogical.
Yeah.
I just don't think it's appropriate to introduce new evidence at closing when there isn't evidence to support her statement.
It's argument, and she's basically saying that the short-term rental license, which she did introduce, essentially, and then also, I'm going to get your name wrong again. I'm so sorry. Napick?
Yes.
Yes. It's the little things in life. So that Mr. Napick testified, I believe that there was previously a long-term rental license and that it had been a legal ADU for some period of time. So those facts are in evidence, and the argument is based on those facts and in response to what you said. So I'm going to overrule that objection. Go ahead, Ms. Panko.
Okay. She had mentioned that I sought a license with an illegal ADU, but that's not the case. At the time that I sought the license, my home had been approved as a single family dwelling. And the city had not identified it as illegal in any way. In fact, the opposite, they had approved it. They had approved the single family dwelling status of the house. That is kind of the core issue of all of this. It was approved as a single family dwelling and issued a short-term rental license. So it was fair for me to believe that I was in compliance to go ahead and rent the space. And then there were various types of backlash from the city when they have just guided me into the changes. The inspector who came and told me, okay, you're now a single family dwelling, actually created the issue of the ADU being illegal, because before that, the home had a legal ADU. And I never would have intentionally changed the home into an illegal status. And he did not change the home into an illegal ADU. He changed it to a single family dwelling. And then Todd and Kimberly sent the notices of violation alleging that I had an illegal ADU when in fact the city hadn't approved me as a single family residence. So that is where the information was conflicting and confusing for me as a homeowner. And then in response to the as applicable, I had a lengthy conversation with Jen and Chad, which she doesn't remember. Where
Now's the proper time for that.
That was the proper time, where it was all about how as applicable meant that there were exceptions to that, including spaces that had never had an interior door potentially being exceptions. And when I was doing the remodel, I had asked the city for blueprints, which they said did not exist. And I had made my decisions based on that and based on the guidance of emails I received earlier from the city, which led me to believe that I was an exception from requiring an interior door, because I didn't believe I had previously had an interior door. The reason for that is that the kitchen, when I purchased the house and moved in, the kitchen completely obscures where the door had been. And same with water pipes and gas lines. The space was completely not door-like whatsoever. And the rest of what is now the alleged illegal ADU has concrete walls, and no door would have been possible at all in any other area. So I believed it had never been connected. And then when I got these notices about the illegal ADU and talked with Chad and Jen, only then did the city search for blueprints in order to make a case that there had been an interior door, which is, it's help that I could have been offered by the city when I was doing the remodel. And they told me they had no blueprints. And those same blueprints were used as evidence against me.
I'm gonna object to that. There weren't any blueprints admitted into evidence today.
There was discussion of blueprints. So understood, but there was some discussion of blueprints, so I'll allow it.
Yeah. Forget where I was. I mean, I talked with my contractor as well. In general, my interpretation of the home was that it didn't make sense that there had been a door. And so I did the whole remodel based on that. And then on top of that, the inspector for the city came and said, you're compliant for single family residence, like you're certified. And my understanding is that's why then the short-term rental license office, based on that, also issued me a license. They wouldn't have issued me a license if my property had been classified as a home with an attached illegal ADU. They issued me the license because I had been confirmed as a single family dwelling. And I think to approve all those things and lead me into, helping me create my business, to do short-term rentals, and then to belatedly find fault with it and crack down on me, I felt was inappropriate. It was just kind of information in the wrong order. The inspector who came could have said, oh, look, this is not compliant. I can't change this to a single family residence. And because he did make the change, that's actually what made me illegal. So the city's own actions created the illegality of the home, and now I'm being fined for having an illegal home. I never would have been fined if the inspection had just said, hey, this isn't legal because you don't have an interior passage. Or if I'd been advised about that earlier on, when I asked the city what I needed, and they didn't mention that. I only signed this declaration mentioning interior passage after other guidance. They didn't tell me about that, and after the whole remodel was already done. And then even when I did receive it, it sounded in the wording as applicable, but it may be an exception if the door didn't do this. Sorry, this isn't the most succinct. I'm just trying to make sure I cover
You're good.
everything. Yeah. So part of the issue now is that I've spent quite a lot of money literally to do what I thought was complying with changing the kitchen into a wet bar. And now the only possible location for the door would involve completely removing the wet bar. And I would have to cut through the plumbing, cut through the gas lines. It's a major change. And if I'd had the information correctly from the city earlier, I would have done it correctly the first time. On top of that, because of the confusion created by granting me the single family home status and the short-term rental license, I entered into creating a business that was quite costly for me to set up. And then I lost all of the expected income from that business almost immediately. It only ran for about a week. So there was a major loss of income. I wouldn't, if I'd had the correct information, I wouldn't have removed the kitchen to begin with. So there was the loss of the kitchen as an asset. If I thought it needed to remain an ADU, I wouldn't have removed the kitchen. And then I sent the email to Chad saying, yes, I would add an interior passageway because there wasn't any other option offered to me. Really, the other option was to make space back into an ADU, which would cause me to not be able to run the business entirely with a short-term rental license. And I wanted to run the business, so I said, okay, I'll make the interior passageway. Then after I sent that email, I talked to my contractor And only then did I discover that the only possible location was directly through the kitchen, because the rest of the space is made of concrete. So, yeah, I said I planned to do that. Then once I had more information, I realized, you know, how costly it would be. And just kind of having to undo all the work that I just did in order to be what I thought was in compliance.
Is that everything?
Well, additionally, in terms of damage to my Airbnb business, which had just started running and was doing really well, this assist that came from Kimberly Barnett was like informal and not it was non-compliant and didn't offer me the opportunity to appeal or any period of time in which to correct the issues. Whereas the cease and desist I got from Chad offered me 30 days to correct the issues. The one I got from Kimberly just said, shut down your business now, and didn't even offer any kind of formal documentation. And so I didn't even realize at first that I had the right to appeal. It's kind of a separate thing, but related. Yeah. Try to word a couple things better. The blueprints, well, essentially that the remodel was completed in reliance on city approval and missing records.
I'm sorry, I did not hear that last part.
The remodel was completed in reliance on city approval and missing records.
Oh, and missing records, that's the part I didn't hear.
Those being the blueprints. And the compliance would now require the destruction of a newly built code compliant wet bar at substantial cost. So essentially, the current illegal ADU status, the penalty result from city caused reliance, inconsistent enforcement, and lack of due process. The home previously contained a legal accessory dwelling unit. And I initiated a formal process with the city to remove the ADU and return it to a single family dwelling. I don't know how clear all of that is.
I think I get what you're trying to say.
Okay.
You actually did a nice job today.
All right.
I've done a number of these and
I'm trying.
you're doing.
I think if I understood how complex, I should have gotten a lawyer, but yeah. It's all, I haven't been to court before, it's all different.
Well, if you understood exactly how it worked, I think I would be concerned about you. So, all right, and did you have anything else you wanted to present?
I mean, actually, I did actually have the blueprints that led me to believe there hadn't been an interior door, but I forgot to submit them. That's probably no good, right?
Can't argue that, they're not submitted.
Okay. Yeah. No, that's all.
That's all? All right, so now Ms. Keller, again, because she has the burden of proof, she gets the last say. So anything that you said in your argument, she can now respond to, and then the case is done.
Okay.
And it will be up to me. So Ms. Keller, anything?
Just one moment, Your Honor.
Okay.
I don't think so. Thank you, Your Honor.
Okay. All right, that concludes the evidence and argument presented in this matter. I ordinarily, on a quasi-judicial hearing, would take a few minutes and roll from the bench. I'm not going to do that this time. I'm going to take this under advisement. I need to look at some things, namely the documents that were presented. I want to go over the timeline more closely, and go over this more of the specifics of what's in each document. And that's going to take me longer than a few minutes. So I'm going to take this under advisement, which means I'm going to take some time.
Don't yell at me, Java Puppy. Do not yell at me. Do not yell at me. I told you. Do you want me to answer that question for you? I don't know. 45 minutes ago, I would have told you. I know. I told you. Don't yell at me. Then you came in with all caps and you're yelling at me. What was I supposed to do? I can't. Yeah, I know. You're yelling. You're yelling. Everyone's yelling at me. I'm just glad the video's over. Oh, we still have 4 more minutes of this. Let's go.
To issue a ruling. I will have a ruling out this week. So no later than Friday. Well, let's say no later than next Monday. Simply because if I don't get it out, I'm traveling for the holidays and I will be in the car for 15 hours on Saturday. And if I don't finish, that'll be a perfect time to finish it up. So I will try to get it out by Friday. I will make it I will endeavor to do so, put it that way. So anything further from the city?
I don't think so.
All right, Ms. Panko?
Yes, I forgot to say one thing. I guess it is my hope that the property could be, that an exemption could be made from the necessity of an interior door due to.
That is not an issue here.
No,
that is not an issue here. It's whether or not there's a violation.
okay, and if I do have an issue with that, where could I bring it to?
It's planning and development that takes up those things, so that's who that would be taken up with. But yeah, it's not an issue in this case. It's not something I'm going to decide on.
Okay.
Okay, any other questions?
Maybe relatedly, like the fact that the home was changed into a home with an illegal status by the city, if that could be.
But you made that argument.
Yeah, no, but the request is that be reversed by the city rather than requiring me to
Well, I'm not the city.
jump through a bunch of hoops.
That would be planning and development, who you would take that up with. I'm not the city, and that's not at issue here today. There's 2 issues here today. One, because you brought them up on appeal. One, did you actually violate? And then 2, if you did, is the penalty that you've received appropriate?
Okay.
Does that make sense?
Yeah.
So any of those other things, if you're talking about exemptions or reversing something imposed on you by the city, then that would need to be taken up with the agency who did those things. Does that make sense?
So if I want to contest them, way to
Contest what?
the decisions of planning and development.
You are contesting the decisions of planning and development here with respect to was there a violation or not? With respect to, it sounded like you're seeking an exemption of some sort. With respect to something like that, only the agency. I don't know enough about planning and development to know if they have the authority to grant an exemption, but if they did, I would imagine that there's some sort of application process.
Okay.
And it would be that department that you would take it up with.
Got it.
Okay, do I have that correct, Mr.
Yes.
Epic? Okay, all right, excellent. Anything else? No? All right. Mr. Napick, did you have any questions?
No.
Okay. All right, that concludes the hearing for today. Again, I will endeavor to have something out by Friday. If I don't make that, it will be out before Monday or by Monday.
Thank you.
All right. Stop yelling at me. Looking at you, Java. Stop yelling at me. That is it, though. That is it. A 3-hour stream. Oh, man. Oh, man. Now you know why I started at 1:30 instead of 8. Anyways, have a great rest of your New Year's, everybody. Tomorrow we go back to the normal schedule. I think tomorrow's Friday. Hopefully we have some courts and I have some content for tomorrow. So yeah, we can hope. We can hope some courts will be open tomorrow. We might not be back fully till Monday. So if I'm, if I don't stream on Sunday, it's just because it's a lack of content. I'm gonna try my best to get some stuff together. But yeah. When courts are mostly closed for a week, it's hard. All right. Have a great rest of your evening, everybody. Thank you guys so much for the super chats and hanging out for as long as you did. This, like I said, was a longer stream, so I do appreciate it. You are awesome, mods. Thank you so much for as well hanging up the entire stream. There's only a few of you that were here the entire stream, but I do appreciate it. I do appreciate it. Good. All right, I'm not gonna say. Anyways, have a great rest of your day. I will see you all tomorrow, and yeah, I think that's all I got. Did I say thank you again for the super chats? Thank you everyone for the super chats, the gifted memberships, the membership milestones, everything. You're awesome. Till next time, bye. Okay, bye.
All right. Take care. And we're off the record.